sponsored privacy panel. We're going to wind our way through a couple of topics focusing on data privacy, internet security, and open access on the internet. I'm going to pause naturally between some of the topics, so feel free to hold your questions, but ask them based on sort of each topic throughout the presentation. Introducing myself, I'm Justin Freeman. I'm a corporate counsel with Rackspace. I'll be moderating today. Going down the panel here in no particular order, just from my left to the end, is we start off with Mr. Scott McCollough, who's the principal at McCollough Henry PC. He's an attorney whose practice focuses on telecommunications, internet law, economic regulation, and he represents the interests of consumers, competitive communication companies, and technology application and service providers. To his immediate left is Mr. Yokubaitis, the co-CEO of Golden Frog, Giganews, and Data Foundry. Ron has founded a number of tech companies, including Giganews, Data Foundry, and Texas.net. For some of you probably use that for your modem access back in the day if you grew up in Texas. Golden Frog was created in particular to develop services that give people the ability to protect themselves online and to access the internet in an uncensored fashion. Directly to his left is Mr. Brian Haas, who's a legal fellow at the ACLU. Brian is a fellow with the ACLU's Speech, Privacy, and Technology Project. He's worked on a wide variety of free speech and privacy litigation, including challenges to the government's use of location tracking technology, the suspicionless search of electronic devices at the international border, and the compelled disclosure of an internet service provider's private encryption keys. And down at the far end here, we have Mr. Scott Henson, who's the policy director at the Innocence Project of Texas. Scott's a political consultant who's worked on Texas criminal justice policy for over 20 years. He writes a widely read blog at gritsforbreakfast.org and is co-founder of the Texas Electronic Privacy Coalition. So I'd like you to join me in welcoming our panelists today. And without further ado, so privacy is a pretty broad area. We're going to dice it up a little bit, but just to kind of kick it off with something, put a pin on it, and I'd like to just go ahead and start with you, Scott. What do you see as the biggest threat to consumer privacy in the technology space? And do you have any solutions you would propose to either eliminate, mitigate, or alleviate that threat?
I consider that there are really three basic problems and one really important potential solution. Society is now becoming much more aware based on the Snowden revelations and other things, but I don't think that folks really understand the scope of surveillance that we have in our society today, both by governments and private interests. Nor do people really understand how the information is being captured and what it is used for after it is being captured. Many folks may believe that they have nothing to fear from a surveillance society. I think that everybody does. People close the blinds to their windows at the house for a reason. They close the bathroom door for a reason. Everybody has something to hide. And to bring it home to the electronic society, if you happen to be using a tablet or a cell phone while you're sitting on the toilet, you know, folks may not be aware that there's a technology that allows the webcam to be turned on and the microphone to be turned on, even if perhaps the on switch is not on. And they can see everything in its glorious detail. People do have something to hide, even honest, upstanding, God-fearing citizens. In fact, I would suggest that in some respects, they have the most to fear from the surveillance society.
Well, I'd like to hear your thoughts.
Well, let me turn on. I think I'm here. Can y'all hear all right?
Yes, perfect.
I would say even non-God-fearing people have a lot to fear too. So it's everybody that everybody. Let's speak better. I'm sorry, Bob. Can you still hear me? Yeah. Is that all good enough? I'm just trying to not let the device feedback. But even like I said, non-God-fearing. This is something that we, can we get the audio audio down? Do I have an audio control on here? Beginning. Right. Okay. That'll be better. We filed back in '06 about this with the FCC and about the deep packet inspection by AT&T. And it's in your terms of service. So anybody with AT&T service, you gave them permission when you click wrapped in consideration for them filtering spam and everything to collect all your data and keep it as AT&T's work product. That's the short for the legal jargon. You didn't read, and you don't have to read an internet or telecom lawyer to read it, snap to what they're doing. So you already gave it up voluntarily. So as hip as all the Linux gurus are in the room, y'all are giving up stuff, writing up, the Gmail account, of course. Now Google says, we've got encryption to protect your privacy. Except you can't do it, protected from Google. But nevertheless, I'm just so happy that Greenwald got people's attention because, you're just crying in the wilderness. And even good geeks sit there and just push back. But you're not going to be anonymous. That is, we've argued against that on Usenet. You can run, but you can't hide. You can do all sorts of things, but if they want you, they're going to get you. And if you don't believe me, go talk to Osama bin Laden. So, if you get, at least with Bitcoin, it's not anonymous. It is pseudo-anonymous. They'd say so. The blockchain is just awesome, but still, they can chase back down that chain. So you just need to put your clothes on, as Scott would say. It's not so much you got something to hide, it's just, as my wife taught me long ago in their family, it's just none of your damn business. It's that simple. It's none of their business. You have private stuff, and it's yours. And I think Andy up in Washington got Senator Cruz to, say in an answer to a question, is people's information their own property, their private property? And he said yes. Well, that's what they're getting. They're stealing your private property. You wouldn't do that. You're going to hold on to your wallet and keep it out of view. So I would just try and activate you personally. Take the blinders off. Sure, you secure your networks, your servers, and everything, but here you are flapping in the wind out here, and it's ongoing. But we're not going to be anonymous. We're just going to be able to let them go pick the low-hanging fruit next door. But you just try and not be the nail that sticks up too high.
Brian, your thoughts on the largest threats facing consumers?
My pleasure. I'm going to start off by just issuing a general disclaimer. What I say here are my own personal views and not the views of the ACLU. I think the biggest threat that we have to privacy is what I call the mosaic problem. All the time, consumers and citizens are giving off lots of bits of seemingly innocuous information. Where you are, what your IP address is when you log in, all kinds of just tiny little bits of data that you're just getting off all the time as you go about your daily life. In addition to just like location information or IP address, you've also got now biometric data, fingerprints, eye scans, face scanning technology is something that we're seeing increasingly used. And so the government and large corporations like Google or Facebook or what have you are increasingly able to collect, retain, store, and analyze this data. And then thanks to the use and the development of big data algorithms, they're able to take the data and then figure out incredibly prescient things about your life. They can figure out whether you're a heavy drinker, whether you cheat on your spouse, what church you go to, what libraries you visit, how late you stay up, when you get up, all kinds of things. And even just little variances in those things can be surprisingly revealing about the personal things that are going on in your life, what you're thinking, what you're doing, what your habits are, what your vices are, what your virtues are. And these are things that we've traditionally thought are private, that the government couldn't get without, at the very least, a warrant. And sometimes we thought there were just practical barriers that prevented the government from getting it at all. But increasingly, the government is able to figure out all these things, and it's able to figure it out from data that's publicly available to it, at least under current laws. And so I think the big problem today is how do we address this mosaic problem? It's a hard thing to do. I think the first step is just to recognize that there is a problem, and In that regard, I think Edward Snowden's revelations have been incredibly helpful for showing people the scope of the surveillance that's been going on, the size of the dragnet that everybody is getting caught up in. But once we recognize that there is a problem, the next step is figuring out what to do about it. I think a big step in that regard would be to pass significant legislative reform. The Electronic Communications Privacy Act is more than 20 years old, and it's about time it got updated to actually regulate the technologies that exist today. I mean, 1986, you didn't have Google, you didn't have Facebook. Email was a completely different kind of thing. You would actually just download it from some server and store it on your laptop, and you wouldn't keep it up in the cloud forever, where it is now. And so the law is just not at all designed to protect the kinds of information that we actively store online now. In addition, we want to encourage companies to self-regulate. And so if companies realize that consumers really care about their privacy, that they value it, that it's not something that they can just take for free, that there are economic costs to invading consumers' privacy, then I think we'll start to see more self-regulation from companies, and hopefully we'll move towards a more privacy-protective sphere.
Great, thank you, Brian. Scott, your thoughts?
All right. Thanks for having me, and I apologize. I've got a little cold coming on, so no one shook my hand, and I apologize for my. There you go. Maybe that'll get us there.
All right.
Yeah, that's not what you want. So I'm not too. All right. I guess the thing I would add is that there are just a lot of layers to these issues, and it's like peeling back an onion. And we have to distinguish between the federal and the state values. The federal ECPA, as we just heard, is a mess. It was kind of a mess in 1986. It's just a ridiculous mess today. It was written at a time when no one had any. Written at a time when no one had, a significant amount of storage. How much storage was on your computer in 1986? And so the idea that someone would keep 10 years worth of email was really almost mind-blowing. But, who doesn't have that or close to it, somewhere, on an email account. Texas law incorporates ECPA by reference. It says, that they can get it under these 3 different standards that all conflict, or you can get something under that federal ECPA standard. So we've sort of linked ourselves to that. As far the only thing I would add on the commercial, on the consumer aspect, I try and make a distinction between some of the commercial privacy issues and issues surrounding law enforcement and the government. I think it's one thing if you're sharing data in an app via these terms of agreement. It's another if the police just have the authority to track you, because they also then have the authority to try and arrest you or put you in jail. That those raise civil liberties issues beyond the terms of service. I couldn't agree more. That is another just big mess that I don't know how you get out of that hole. There was a famous episode that I'm sure many people here have heard of where a company in England created terms of service as sort of a satire spoof, and said, this isn't exact, it's been too long since I read it. It's something to the effect of that if you sign these, terms of service, you agree to, hand over your firstborn to Satan and to, pledge your eternal allegiance, to, his dark holiness or whatever it was. And did this for several weeks and then announced it, hey, this is just a joke, we just want to let y'all know no one is reading these things. And then no one in that whole time had, ever read through it and say, oh, wait, can I get your email service without selling my firstborn to, the Dark Lord? And so, that is a huge issue. But I think it is separate to me from some of the law enforcement issues, which are just cleaner. You're just handing out so much consumer information that it just makes it a lot muddier. And there are some people who will say, you know what, I'm willing to give a little personal information to a company because I want, $1.25 off of my next, box of detergent. or whatever it is they're going to get in exchange for that, and that's muddier. The law enforcement issues to me, do you have to have a warrant? Does law enforcement have to have a warrant? Does the IRS have to have a warrant? That's, yeah, go ahead.
Yeah, Scott, when you were talking about how Texas referred to the ECPA, the Electronic Computer Privacy Act, in the last legislature, I believe we passed a statute, because I know Scott wrote some of it, Andy Lockford, or he wrote Lockford.
Right.
And that is that in Texas now, a search warrant is required for email and content of your internet communications. Oh, sorry. Good. So we've kind of remedied that in Texas. We're the only state so far. Other states have been looking to follow the Texas statute. I know Andy, that works with us in the room, went to South Carolina and Florida. So we're trying to get the ECPA in Washington, where it's, you know, the Crips and the Bloods, to follow the Texas statute and require a search warrant and probable cause rather than just direct surveillance. So it's, you know, you're freer here in Texas than any other state. You're more secure and more private in the law enforcement issues.
Yeah.
On
email and content. There were two big bills last session on these topics. There was one on geolocation data, and there was one on the email and content. Email and content passed. Geolocation data was approved in one chamber by 126 to 4 votes, and in the other chamber didn't get out and did not become law. And so the geolocation really is what I'm referring to. Definitely,
okay.
Email was a good, email content was a great get. And I'll tell you, the Tea Party folks are ready here in Texas. It's kind of funny. The breed of Republican who is populating the Texas legislature today is not your granddaddy's Republican. It's pretty funny to see some of the more libertarian-minded folks who see this stuff and are just automatically, well, obviously they shouldn't do that. It's been pretty remarkable.
What's the days of law and order uber alles of the Republican Party is kind of over because you've got too many Tea Party people coming in and say follow the Constitution, and this is the Constitution.
Right. Well, and it's funny, you know, some of these guys believe their own hype. It's, you know, you hear it and it sounds, you know, oh, less government, that's hypocritical. Some of them are fairly real about it. I mean, I've had Tea Party type guys tell me, look, the U.S. incarcerates more people than anyone else in the nation. Texas incarcerates more people than any state in the nation, which is true. You know, and if I'm for less government, how can I actually, you know, support that? How can I not try and scale that back? Well, some of those guys believe that stuff. That's not just rhetoric for them. And they're in charge now, so we'll see. You know?
I don't know if there's enough copies, but I left a recent poll, some 30 copies of a recent poll dealing with how the various liberals versus conservatives view the NSA program in particular. And the information is quite surprising. Almost across the board, you will find that what they call conservatives are far more opposed to the NSA surveillance program than are liberals. Now, that's a bit of an overgeneralization, but generally speaking, you will find that in today's environment, those who call themselves conservatives are far more suspicious of surveillance programs by the government than are those who call themselves liberals. On the other hand, you will find that conservatives are far more understanding and willing to countenance the gathering and use of information, private information, by private companies. And, you know, in my own personal opinion, I am concerned about both. Because ultimately, if a business gets it, then of course it can use it for its own purposes. But also, once a business gets it, then the question becomes how easy is it for the government to then obtain it.
If I could just jump in for a second on that.
The third-party doctrine is this kind of abstruse constitutional law doctrine that came about in the 70s, but what it essentially says, and what the government has used it to say, is that when you give a business your private information, even if that information is basically necessary for that business to operate. So your cell phone location is used by cell phone companies to provide you cell phone service. But as a result, they also collect a ton of information about where you are through your cell phone, just pinging the cell towers. And then the government comes into the cell companies and says, well, the consumer's already given up that information to you. No more expectation of privacy in that information. You have to turn it over to us. So under the third-party doctrine now, what happens is when you give information to a business, the government then comes in and says, well, there's no more privacy on this information. It's already been given over. So we're entitled to it. And so that's really, I think, in a constitutional sense, they're connected in that way. And that's why I think it's really important, at least legislatively, to try to overturn the third-party doctrine. And also, the ACLU is fighting in the courts to try to limit it. Because it's clear that it's leading to results that were never intended or foreseen by the Supreme Court when they handed out that decision.
Sure. Well, it sounds like we have a consensus then, a couple of things. So first of all, one of the major problems facing people is that lots of private companies gather lots of data about you, which can be accessed by law enforcement, or which they can share, putting together a picture of you that substantially invades your privacy. Do you guys think, you've talked about how problematic it is when companies use effectively boilerplate or terms of service that obfuscate or vary what they're going to do with your information. Do any companies stand out to you, or do any approaches that stand out to you as particularly good or particularly bad in terms of companies informing users about what type of information they're gathering and how they're going to be using it? I'll just throw this out there.
I have both drafted and analyzed the privacy policies of countless companies. And when I am drafting them, it is an exercise in taking away your privacy. It is an exercise in having you waive all expectations of privacy, all rights to it, giving the property rights to me and allowing me to use it for anything I want. It is much like the HIPAA releases that y'all do when you go to the doctor. In the name of protecting your medical privacy, you're supposed to file this form, and you think, oh, great, my privacy is protected. Instead, it is an exercise in waiver. Now, who has good policies? Well, since Ron over here is my favorite client, I'm going to tout his privacy policies. I would commend them to you. They basically say your information is yours. We don't want it. We don't want to fool with it. We think you ought to encrypt it and keep the key. And the only time we're ever going to turn it over is when the government gives us a warrant. And they say it's clearly and succinctly and without qualifications. I challenge you to find any other company, and in particular internet access providers, and in particular even my friends over at Google, to be so clear about what it is in terms of protecting privacy. There are reasons people do not read these privacy policies. They are obtuse, they are impenetrable, and only a lawyer can understand them, and that takes efforts, and we don't do anything unless we're billing.
Well, let me defend myself. But listen, I can talk to some of the enlightened ones in this room, and I really feel like I'm talking to pretty hard head, because very combative, but assume, and you just can't assume, and assume the worst and protect yourself. And just because someone says they don't log, they are logged, especially if they're in the cloud setting. They don't, you're renting servers, but you don't control the logging on a cloud-based server or the network flow stats coming off those routers. Somebody else does. So how can you say you don't log? Because the logging, you just quickly go to the hosting provider and you get all whatever you want to get off the hosting provider who will divulge it. We could let Brightspace talk about what their policies are.
Like moderator right here.
Hey, we're all players. But there's severe problems unless you are have your own servers, know them, routers, switches, and even your DNS. Okay, Google DNS. Hi, I'm from Google, and I'm here to help you for free. Now you know Google DNS has got all that critical data to be able to seek for an IP address that you or your customers, anybody uses. So you need to start looking at the big hole in your privacy that is Open DNS and Google DNS. There's no free lunch, as y'all know, should know. We didn't grow up in a free lunch bunch. There's no free lunch on the internet. So when you find a free lunch, you're the lunch, of course. So you're just going to need to take more. At first, you're going to have to believe it's a problem, other than what Snowden says, But the name I'm reading, one of my sons gave me what's the Greenwald's book. I'm about a third of the way through it and fall asleep. But no, it's a good book. I took it a long time today. And but what does he say? You can't hide. So you can run. You can encrypt. You can go from here to there and run your proxies around the world. But still, you can't hide. But you're basically trying to. It's still security through obscurity. But you need to obscure yourself a little more. Go ahead.
I think Ron's exactly right. I think you should be suspicious of any service provider that gives you something for free. Generally speaking, on the internet, nobody does anything for free. And so, Dropbox is a classic example of a company that provides what seems like free storage and actually just has access to tremendous amounts of your personal data that you just load up there for them to look at whenever they want. And I'm really gratified to see that now we're finally seeing some companies like Golden Frog and previously LavaBit before it shut down come forward and offer these paid services. And what we're seeing is actually consumers really want to pay to protect their privacy. They're willing to pay to protect it if it's something they value. And hopefully going forward there'll be more options for people who really want to protect their information. The danger still is that even companies that want to help protect your information aren't always able to do it. And I think LavaBit is a perfect example here. LavaBit was a secure email service provider created by Ladar Levson, I think right out here in Texas. And it encrypted all your email, gave you the key. The idea was that LavaBit itself could not read any of your email. Its profit model was based solely on your paid subscription to the email service. Well, the government decided it was very interested in somebody who was using LavaBit servers. There's speculation, no one's ever confirmed it, but there's speculation it was Edward Snowden. And they wanted to do an investigation, so they went to LavaBit and they said, okay, we want to install a pen register device, a surveillance device, on your server so we can collect all the information that people are using as they're interacting with your servers. From that, we're going to figure out what their private keys are, and then we're going to decrypt all their information, or all the information of the person we're looking for. Ladar said to the government, I can't give you my private keys, those protect everybody. I've got one set of private SSL encryption keys that secure the email traffic for everybody who's interacting with me, so they know that it's me they're interacting with, not some other company, not the government. And the government said, too bad, we promise we'll only look at the person we're looking for. We promise we won't look at anybody else, but there's not like they were going to sign a contract saying that. They were just telling him this. So he said, I'm not going to do that. You can't force me to blow up my business just to give you this one person's information. If you want this one person's information, come with a court order for that person, and I will give you that information myself. I will create code in the program to download that specific information and give it to you without compromising the rest of my user's security. And the government said, too bad, we don't want that. That's not the kind of process we want to do. We want to run it ourselves. We want to install the device. We want access to everything, and then we want to pick out the person. We don't want to have to rely on you. And Ladar, I think, very heroically said, I'm not going to do this to my users. I made a promise to them. I advertised this way. People trusted me. And he shuttered his business. And the government still moved for contempt sanctions against him. I think it was on the order of like $5,000 a day or something like that. He appealed it up to the Fourth Circuit. And the ACLU filed an amicus brief on his behalf. But ultimately, the Fourth Circuit said, oh, well, you waived all your arguments, because he was representing himself before the district court. He wasn't able to hire a lawyer in time, because the government was just railroading this through the district court process. And he didn't know what he was doing. He's not a lawyer, so he didn't know when to object, what to say, how to say it. And the Fourth Circuit said, well, too bad you waived your arguments. There's nothing for us to do here. Contempt sanctions are upheld. And that company was shuttered, and Ladar's contempt finding was held in place. And in the wake of that, you saw a number of secure email service providers say, wait a minute, if the government can get these keys, our users' information is not secure either, and they all shuttered. So one of the things I think we're going to do, if we want to see companies actually take this really proactive stance, and we want to encourage it, is we have to make sure that there are reasonable limits on what the government can do as part of its investigations. Even when it has a court order, that order should be specifically limited. The Fourth Amendment was all about fighting general warrants, this idea that the British could just come into your house and look for whatever they wanted. The idea was that it would be specifically limited to the specific thing they need. And I think we need to make sure that those limits are put back in place.
And meanwhile, find a service provider that lets you have your own key, and where the service provider does not retain that key.
Scott, do you have anything else to add?
Yeah, especially for this crowd. Even Scott mentioned that, if someone comes with a legitimate warrant signed by a judge, that they're going to go ahead and give the information out. And, if it's encrypted, that's one more people for them to jump through. But it's not impossible for them to eventually, to get to that. For folks who are developers, for folks who are producing products that may use location data, that may have that as part of what your service is, keep in mind that there is one kind of data that they cannot access, and that is data that you have not stored. If you don't actually store non-essential metadata over time, then it's not there for them to get. And that just sort of solves the problem, that end. And I think now that everybody's seats done, and then the aftermath, that becomes more reasonable. Saying that 2 years ago, you sound like
Yes, and right, wing done.
yeah. But I'm telling you right now that especially because I work more on government type issues, government type databases, making sure that data doesn't just sit there forever, so jack somebody down years from now. It matters, and data retention is going to be a bigger issue. I'd also add a lot of it. While I agree with most of what you said, I would also say that was almost a textbook example of how not to handle a legal situation when law enforcement comes knocking at your door. And there have been a lot of writings among sort of the legal set nationally of how all that went down. A lot of hotshot criminal defense lawyers think that if instead of trying to do this pro se, this poor guy, I say poor guy, you make a decision to represent yourself against the U.S. attorney. I don't know that much sense. I mean, there's a Darwin's law, scenario there that that's just going to happen. And if he had actually understood his situation and immediately lawyered up and immediately went out and sought somebody who really knew what they were doing to fight it, I think they wouldn't have set some of these really bad precedents. There's a blog from a lawyer out there called Civil Justice who's written a lot about this and links to all sort of the pro and con debates about how it's handled. And so go to his blog and search a lot of it. You can sort of read a lot more sort of why the criminal defense set thought, gosh, how did you let that happen? Well, it's because the entire lawyer tried to per se, if your business is worth paying $3,000 to get legal advice when the friggin' FBI knocks on your door. So don't keep the data, call a lawyer when they show up, and don't try to.
I think Scott and I both can't argue, rather, with your advice that you should always find and pay a lawyer whenever you go to the I'm going to pause here for a moment and answer some questions. I know that we're diving almost headfirst, and under the surface of all this discussion is comments about law enforcement and legal reform from government access. I'd like to pause, though, for questions about commercial and consumer privacy, if you can limit them to those for a moment. Yes, sir.
I have one question. Have we ever considered the idea of doing some kind of open standard for these agreements? If using any user license agreements had common framework across the industry, just like any of the other standards, DNS, SMTP, or whatever protocols, maybe that would make it easier for people to understand what the language of the agreement is.
So for those who couldn't hear, the question is relating to whether we can have a common platform or sort of an open source standard for privacy and user information and disclosure agreements.
I would certainly commend it. I mean, you know, there are several models for that in the intellectual property world. And I'd be happy to work on a project such as that. I've never heard of one being tried, but I think the industry would be well served, as would consumers, if there was a specific template for a privacy-enhancing set of privacy terms that people could understand and rely on.
Well, especially if that included a scoring component.
Yes?
Anyone else?
That's not pay grade.
Who actually installs all the equipment or software that's out monitoring this? Is it the FBI or NSA? And, who can we talk to about making them stop?
You know, I generally make my business make my living representing businesses, and sadly, I'm quite often pointing the finger at those very entities. The folks who have installed the surveillance mechanism for our country are the same ones who sold the information to the Iranians and the Chinese for the Great Wall of China. They're very prominent companies. One of them begins in C and ends in O. They have equipment in virtually every company that is in this space. Y'all might be shocked to see what's running on their motherboard and in their firmware.
Also, you know, a provider like us gets a FISA court warrant, which we can now say we've had. Until a few months ago, you could never even divulge that you got. But those will be to locate often to locate pieces of equipment on a port, say on a hoster. So the data center operator gets the thing. The hoster may or may not know. We insist that the hoster know and not be treated like a suspect. So they don't do like what they did to Kim.com or in fact Steve Jackson Games here, the Secret Service back in '91. You know, the case that started the EFF started here with Steve Jackson Games, online games, Illuminati online. Later became the ISPIO.com. But they just took all the servers and all the innocent people, and that's even the suspect was innocent, but they didn't just get his stuff, they got everybody else. Kim.com, they wooed in, and anybody that was storing not a part of what the alleged cabal of copyright infringers, they got their stuff destroyed. So it's pretty clumsy. So you kind of got to, and the same thing, they want to come in and put it, take it off, take the whole server out, still to this day. And you got to resist, and make them specify the person or property to be seized and searched. And it's just still, they just want to blunder, and you've got to resist, you know, call counsel out the back door. You know, this is all the king's horses and all the king's men. This is not Mother May. You know, this is FBI agent shows up. You got a briefcase with a zipper on it, a lock, and it's top secret hush hush. You can't tell anybody in the company you got it. Because I'm the guy that can serve that stuff. And I can't tell anybody in our own company that I just, you know. So that's how it happens. That's the operation of it. And if y'all are in the same spot, it's to keep saying no. But you have to. You have to say no until they get their stuff together. Because they're going to try and blunderbuss you. And you got to make them constitutionally, which is what the Tea Party's saying. We already got a law. They just won't follow it. I got a question for Scott. Has the Innocence Project or the ACLU, but it comes out with y'all, and you got somebody wrongfully imprisoned under Bullhorn, like up in Williamson County, right here. Have y'all looked into the fact that the federal judges are paid by the very company, the outfit that they're asked to sanction, the federal government? I mean, that the judges, I mean, they're asked to cut off that bite that ain't feeds them.
Right.
I mean, to me, I don't think that's very constitutional. I think the federal judges ought to have, it can't be that damn much money. You know, it's not $1 billion on the federal court system. We can put up the money to where the federal government's not giving us money. But they don't owe fealty to the federal government and state government, that they are truly an independent judiciary. I don't think we have one. So you get the Fourth Circuit shoving it down lava bit, or all the really crony decisions I see out of a lot of courts, especially the official FICA court.
So I'm going to give you a quick second to respond. We've got one more question, and we're going to move on to this.
Sure. Well, first I should mention that the Innocence Project in Texas is one of my two main clients. But the reason I'm up here was my involvement in this Texas Electronic Privacy Coalition. Innocence Project doesn't work on these issues per se, but you know, it's very, very easy to get. Once you get caught up in a criminal investigation, even if it's by accident, it can take a lifetime to get extricated. I mean, the worst of these guys spend 33 years plus in prison when you take an exoneration. And so, you know, the consequences of errors in some of this stuff is huge. This is sort of untested forensics. They don't really know error rates. You know, you're tracking from cell tower to cell tower, but you don't necessarily know, you know, when 4 cell towers connect, which one are you really closest to, you know, when they overlap. And so, anyway, all that to say, but maybe that is all I have to say.
One last question this time from the patient gentleman in the back with the sore arm.
So several services have cropped up that offer something called client-side encryption. That's where you encrypt it before you send it to the server, so nobody at the server, even if they have a court order, have nothing to turn over except encrypted information. Do you see that as becoming the norm in offering services? And how do services that depend on actually analyzing aggregate data build their business models around that kind of standard or stack?
I think the most likely thing we're going to see is that there's going to be, you know, a range of options. I don't think the big aggregating services, I don't think Google's going anywhere. I think that the services that offer client-side encryption will hopefully become much more popular as people start to value this stuff. But then, you know, they will likely need to make their money partly by charging their clients. And so there are going to be some people who say, you know what, I don't care, whatever, just put it on Google. I'm fine, send me the ads. Obviously with the ACLU, you would argue that it's not as innocuous as it sounds, but I think that, you know, there'll probably be a range of options, and people will have to choose, you know, how much they value their privacy at the end of the day.
I would just like to say, of course, you can encrypt your own content. PGP's been around 20 plus years. And but one thing you might want to consider is what you can do with what a law professor now terms geolocation evasion, or as we do in Viper VPN for Golden Frog, we take your surveilled IP address from AT&T, Time Warner, they're both surveilled, and just kind of put it on a shelf and encrypt you to another location or another country, and let you be assigned an IP address that's geolocated to that country, such that the data is all about somebody in Amsterdam or Russia. So you could let them have, you know, an encrypted VPN to someplace that is not identified with your locale via your ISP. So there's, you know, but you're still running. But in the end, you can't have. Okay, so it just, and you're not going to, I don't think, encrypt everything. You're going to realize that there are some things you do, some applications you use that you're going to want to encrypt. and some other stuff, you're gonna say, what the hell, it's the price of Google. I mean, but the point is, it's your choice. It's, and if you don't, it takes folks to get active, kind of like in social. Someone else is going to do it. You're going to do it. You need to click on the EFF letter to whomever your compromised Congress critter is. Okay, no matter what, either party, it doesn't really matter. There's a few that are more guilty than others because they got more awareness of the internet. But y'all have to do something, just as a person, personally to encrypt, personally take measures, and publicly via letter, email, put in the pressure, because they're only going to respond to awareness of pressure.
In some respects, the law generally tracks the technology here. There is a distinction between the so-called header information, which when we in the practice call metadata, and the actual payload, which we call the content. It is difficult in many respects to have any real protection of the metadata unless you are using a VPN service, which can only protect some of it, even in any event. It is far more possible for you to take action to protect the actual content, the substance of the information that you are conveying. And because you have the right to avail yourself of some of the encryption options that are available. But even then, it's limited. There are now offerings here on the market. Ron over here has one. It's called Dump Truck, where you can encrypt your information and upload it to the cloud, and it is stored in an encrypted fashion, where you still keep the key. And so if Ron gets a warrant, what he hands over is gibberish. But if you are talking between two edge points, two edge devices, who are going through each other on the network, it is still to this day somewhat difficult to have good encryption of the content on an end-to-end basis. The two edge points have to have a way to negotiate the exchange of the key. And I think you guys are the technologists in the room. If you can come up with a way to better facilitate the exchange of the key between two edge devices and make it ubiquitous, I think you got yourself a business. I mean, it's out there now, but it's still very difficult for a common, ordinary citizen to make themselves available to it.
We're going to dive now into law enforcement, which I think will be one of the largest area of questions. So I know I saw a whole lot of hands go up just at the last break. Don't worry, we're going to reserve a lot of time at the end here. But I'd like to put to the panel, the USA Freedom Act is currently winding its way, or it's wound its way through the House and is now up in the Senate. A lot of concerns about the last-minute changes that were pushed through on that bill. I'd just like to get your sense of whether NSA reform or just generally U.S. government surveillance reform is possible, and what your criteria would be to consider that reform effort successful. And we'll start at the far end with Scott, if that sounds good.
Sure. It would be just a sucker's bet for anybody to bet on any particular piece of legislation to pass in Congress anytime soon. I mean, maybe it'll happen, maybe it won't, maybe the Cubs will go to the World Series, there are lots of big maybes in life. But, I would not count on that at all. I've been very heartened to see after Texas, which, by the way, we were just a tad ahead of our time. The Texas bills on cell phone location data and email requiring warrants for both, were filed a few months before, written and filed a few months before the Snowden revelation. If they had come 2 months earlier, they both would have passed. One did, one didn't. But they both would have easily, if that had just happened a little bit earlier. And for us, it was a bit of a slog trying to educate people about it. People just didn't understand. Now everyone has heard of it. Even just average folks know what you're talking about. And I think that makes it easier that you don't have to just drag people who are not technologically, savvy, into understanding why they should care about this. So maybe something will pass at the federal level. If it does, go team. If it doesn't, Tennessee, within the past week, their governor signed their state level legislation, say state and local cops can't get cell phone location data without a warrant. Where's that? Tennessee. We've had Montana, Maine, two others, Utah, and one other that I'm forgetting, who've done it through the legislature. And then New Jersey and Massachusetts have done it at their state Supreme Court level. So that's just in the past 2 years. Texas, as far as it passed, would have been the first in the country. And we were the first in the country on email to extend that warrant requirement to content in the cloud. But there's a national push for this. Virginia was the other. And a lot of these are in, relatively red states. And it's a bipartisan thing. So this is, I think you've got a great chance. I think that for this to happen with the states first and then the feds be sort of drugging along, kicking and screaming is more how I see this happening in the end. I haven't seen it pass anything. So, maybe
Fair point, Brian.
I think with the ACLU, you have to believe that NSA reform and intelligence surveillance reform is possible, or we wouldn't spend so much time and so many resources fighting for it. I think the really important thing to remember here is just to look at what's happened in the year since Edward Snowden came forward. It's almost exactly a year anniversary this month. And just a little over a year ago, we had a fight in the Supreme Court, Amnesty versus Clapper, where we challenged the government. We believed the government's metadata surveillance program was, and we got kicked out on standing grounds. Standing is a judicial doctrine saying if you can't show an injury, then we're going to throw you out of court. And basically what the court said is you can't even show the government's doing this. We have no idea if the government's doing this or not. You can't prove that any of your clients or you have ever been surveilled in any way, shape, or form. So there's no case here. We're throwing you out. And then, a month later, or 2 months later, I was sentenced for it. And not only were our clients surveilled, we were surveilled, everybody was surveilled. And what he showed us was that, the FISC, the court that the government has set up to regulate this kind of intelligence surveillance, had been interpreting the relevant statutes in such a way that completely eviscerated their meaning. What the statute said was that the government could collect relevant data. And the FISC had interpreted relevant to mean in any way even marginally useful to the government. So if it's useful for the government to have the haystack so it can find its needle, fine, give them the haystack. And that's just not a reading that anybody reasonably, any member of the public who didn't know what the NSA was doing reasonably thought they were going to do. Of course, the senators on the committee knew it, but they couldn't disclose it because they were afraid they would get prosecuted for leaking classified information. They asked, Senator Wyden asked Director Clapper at, congressional hearing, are you collecting Americans' metadata? Are you collecting Americans' data? And he said, no, not wittingly. He basically lied to Congress. So there was an entire veil of secrecy on this program, and we couldn't have the debate because the government was not willing to admit the very things it was doing. Now it's out in the open. We know what the government's doing, and I think that the public opinion has changed really quickly. And the fact that we're having this discussion at all about the USA Freedom Act, I think just goes to show what a difference the Snow disclosures have made in this very short space of time. And so we're hopeful that, as time goes on and people really dig in and learn about this stuff and the fights are actually waged, that yes, I think some surveillance reform is possible. I think, maybe we'll have another moment like we did in the 70s after the Church Committee hearings. And that will actually succeed in changing this agency culture. Would I bet on it in the short term? Maybe not. But hopefully in the long term, change can happen.
I'm just not optimistic that we're going to get any reform in surveillance and intelligence gathering in the United States by the federal government. I'm sorry, it's got to go through Congress. It's got to be passed on. If you object to it by a court that's paid by the very U.S. Congress and the federal, I think it's up to us each individually. That's it. I mean, I've said for several years that encryption and VPNs are the Second Amendment for the internet. And a lot of people who disagree with the Second Amendment are now touting that. I think the folks that fight for the feature that are the political action group that focused on getting the emails on SOPA, a pretty outstanding group of young people. I've been on a panel with one of them in the South and Southwest. And, but now they, to a man in Massachusetts, be against us gun-tote in Texas. You notice they're not carjackings in Texas. Because they don't know which one of our winches has got a pistol in it. You talk about this car? But you got Massachusetts, but nevertheless, they're using that image for the Second Amendment. What is that? That is us. Each one of us. Not counting on government heavens. So I'm just, really, we lobby in good faith. Just, both parties. We're bipartisan slanderers and workers, but still, I don't put my family's security in the hands of hiding from the government. I'm here to help you. Come on. So I'm not optimistic about, I'm trying, state level, we're working on the ECPA and going back, several Congresses. But we see both parties are entrenched enough that they really don't like it. Only now a little bit. And right now, I think we're at 214 signatories sponsor. How many? 216. We need 218. So I can tell you what y'all could run out of here today and call your influenceable Congress critter, whatever party they are. We need some more Democrats. Lloyd Doggett here, boy, he gets it passed. Okay, he's one of the Democratic congressmen here in this, Democrat stronghold here in Austin. We don't hold that against him. But he snaps on a lot of our internet. He understands and is willing to listen very quickly on internet security issues. So we're very much appreciative. And it comes out. He'll say it. You just got to get to him and talk to him. So if y'all talk to him, hey, you're going to run into somebody somewhere. Rather than talk sports or whatever, just say, hey, what are you doing to protect the privacy of us from national surveillance? Are you protecting your own staff? What about you and your family? Look, help us. At some level, you're not a congressman or a critter, whatever you are. Critter is what we say. It's not sexist. I got that. Lots of stuff like keep your mitts off my bits. But we just try and get the ideas across. But it's up to y'all individually. It's not like somebody's going to take care of you, brother. You're going to take care of yourself. And you better take care of your online self. And just take simple measures. For that stuff, you really got to, I know we do lots of stuff we don't really care about. Out here, Google knows what bra I'm looking for. But, there's a lot of stuff that you just need to protect the person at the other end from your loose lips that's going to sink somebody else's ship. But I'm not at all optimistic about our favorite surveillance state.
It's a rare government that chooses on its own to limit its own powers and to restrict its activities. It is a common government that thinks it needs more information so that it can beneficiently take care of its subjects. The only way that there is going to be any reform with regard to surveillance is if the people rise up and demand it.
That's including geeks.
Meanwhile, you need to take care of your own privacy through self-action. But let me make sure that the audience here understands what the legislation is that's going on in Congress right now, because they've kind of been mixed up a little bit. With regard to NSA reform, the Snowden revelation stuff, there was a bill in Congress called the USA Freedom Act that was originally introduced and largely was a good bill. We worked with with many of the progressive groups, and God, you guys did an extraordinary job on it. And we thought we had it coming out of the House, but once it was voted out of committee, the powers that be in the dark of the night got together and gutted the bill. One of the people who did that, by the way, was unelected just a few days ago by his district in Virginia. So, sadly, what passed out of the House really is not satisfactory in the least. There's an effort now to try to fix it in the Senate. Nothing's going to happen. It's good, though. The folks in the Senate have every incentive to kind of protect their underlings over there in the executive branch because, you know, everybody that's in the Senate, one of these days they want to be over there running the executive branch, right? So, you know, you need to be ringing their phones off and talking to them about an NSA reform bill that actually reforms the NSA. Separate and apart from the so-called Snowden revelations is the amendments to the Electronic Communications Privacy Act. That's the stuff that Scott and I were talking about, requiring a warrant for content. The Texas version of the ECPA was what we passed last year. Now, in the federal Congress, we've been trying to get that taken care of for many years. There was a Senate bill that came out of committee, largely a good one from Senator Leahy. And it has been hung up not because the NSA wants to look at your stuff, but because the Securities and Exchange Commission, the Federal Communications Commission, the Federal Trade Commission, and all these other administrative agencies want to be able to get your content without a warrant by sending a subpoena or something less than a warrant to the service provider. That bill will not come out of the Senate unless somehow or another the so-called SEC carve-out is taken care of. So don't think it's just the NSA that wants your stuff. It's all these regulators with all these letters in after their names. It's not FBI.
Well,
That want your stuff too. And the problem is once an administrative civil agency gets it, then they can turn it over to the FBI without a warrant. It's the same as when a corporation gets your stuff. The government can get it. Well, if one agency gets it, it can freely give it to another government agency. So you need to be aware of what this information is, how it's collected, what it's used for, and what happens to it afterwards. Now, on the House side, there is a Yoder-Polis bill, and that's the one where we now have a fairly large number of sponsors. We're 3 short of the mark.
Y-O-D-E-R.
Yeah. Y-O-D-E-R. If we can get a couple more Democrats to sign on and co-sponsors, we'll get what's called a supermajority. It can be voted out of the House without having to go through committee. And that is a good bill. It is a clean bill. It requires warrant for content. It does not have the so-called SEC carve-out.
We're not going to let the bureaucrats also protect their power, because the bureaucrats want to protect their power. Those are regulatory bureaucrats. He calls them administrative. They're regulators. Some people think regulation is the answer. Big companies just hire more lawyers. Small companies can't handle it, but they don't want to give up power, period.
I became a lawyer when I got out of the Marine Corps because I figured I needed to know my enemy. Once I got my bar card, I started doing administrative law because I found an even bigger enemy. These administrative agencies are almost as dangerous as the NSA and the FBI. They can ruin your life just as easily. Trust me.
At the hearing last year on the self-notification data bill, the one that said they couldn't look at your historical data, there was this long, 3-hour hearing in the House, and law enforcement, Texas House, law enforcement said over and over, oh, well, you know, we don't get this with a subpoena. We always get a warrant, or we get these higher standards, reasonable suspicion, whatever. Well, the very, very last bit of testimony at the end of the hearing, this poor gal from the Department of Insurance, who had no idea what she was stepping into, walked up and said, well, I just wanted y'all to know that that we access this data all the time on nearly every one of our investigations. And we just issue a subpoena. We don't issue a warrant or anything. We just a subpoena. They always send it back very promptly. So that's the standard here. Well, it's very weird.
These were fraud investigations, by the way. They just happen to be civil.
Yeah, that's why I say about the regulatory agencies. And it was just very strange because while Texas law seems to, by the way, Texas law is, I've been going to the legislature since the late 90s. It's the worst written statute I've ever personally been involved with. 5 lawyers, like 7 have been thinking about what that statute means. Maybe debates over this very strange. But nobody really knows what the standard is. It could be a subpoena. There's one reading where you can say it should be a subpoena under Texas state law. There's a reference to ECPA, so it could be the standard in ECPA. There's another section of this very convoluted bit of code that references reasonable suspicion. Could be that. Some law enforcement agencies, because they did not understand themselves what was required, were already getting warrants anyway just to have clean hands, just because they were confused, didn't really understand, and said, look, we got a warrant, we're covered. And so that is one of the most confusing, worst written laws ever. And it's because the technology has evolved so much more quickly than the statutes.
We got a pretty good start to fixing it here in Texas, but now we need to move on to other states and to the federal government.
I could just jump in and talk about one more agency that does this, the DEA. We just had a big case out of Oregon. Oregon passed a law saying, listen, as part of our plan to help coordinate medical care in the state, we're going to have this thing where we collect the prescription drug records and put them in a database. We promise you, as the state of Oregon, that your records will not be disclosed to any law enforcement agencies in Oregon without a warrant. So, when the legislators proposed that law, they built in warrant protections for the citizens and said that was a condition of the law being passed. Then the law gets passed, and the DEA comes in and says, hey, you got all these prescription drug records. We're interested in seeing if some of these doctors are prescribing things off label or whatever. So we're just going to give you a subpoena, and we want you to give us all those records. And Oregon said, well, you can't do that. They said, well, there's a third-party doctrine. Comes right back. They said, these people voluntarily gave this prescription information over to the state. Once they did that, they lost all privacy interest in that information. We don't need a warrant. We're going to give you a subpoena. We litigated this case in Oregon. We said that the government's plan violated the 4th Amendment, and the district court agreed with us. We won a big constitutional ruling out there. We're doing the same thing now, I believe, in Utah. And the government's going to set to appeal this up to the 9th Circuit. Soon, hopefully, we'll get a ruling back. But the DA is just one more example of this, where it's not even investigating the patient, right? It's investigating the doctor. But as a result of them investigating the doctors, all your private prescription information, whether you take antidepressants, whether you take Viagra, whether you take, any kind of mental health drug or physical drug, your cancer medication, whatever, can all be available to the government on a subpoena, on its theory, because of the third-party doctrine.
Russ, you want to follow up quickly? We're going to save about 20 minutes here for questions.
Oh, questions is best. I'm just going to say this, and it's going to pull together what Scott said earlier. The problem you have when you go to the doctor is you filled all that privacy notice paper, okay? And the first time I was presented with that stuff, several years ago when it first came out to protect our privacy, I sat there in the doctor's room and read every bit of it, started scratching off. When I got to the end, I realized what Scott had said earlier, that all that document does is ensure you have waived any element of your privacy with regard to your medical record. So the next time, just circle the part that says he can charge your health insurance on it and scratch all the rest out, or don't sign it at all. And those little ladies up there will tell you it's required and all that, that's BS. It's just CYA for the doctor. When he does turn it all over. Just like AT&T, you gave your consent. So believe it or not, just because someone puts a form that says privacy in front of you, just like RTFM guys, just RTFM, read it. And then you may not want to sign it, but it's just click wrap. But that's how you give it up at the store, the doctor, everywhere, or online.
All right, we've got 20 minutes for questions. I'm going to start on the left side of the room. Please, make your voice pretty loud, and otherwise I'll do my best to.
Yeah, but you have a microphone.
You have a mic?
We did.
Beautiful.
I'll be right back.
There you go, the gentleman over there.
Ron earlier mentioned that the VPN is the Second Amendment implement of the Internet age. The Second Amendment is codified in law. Isn't a fundamental problem with avoiding surveillance and maintaining privacy that the right of privacy, that is, who owns the data, is not codified in law?
I would contend that it is. I would contend that it is contained in the First Amendment, the Fifth Amendment, the 14th Amendment, along with the Fourth Amendment. I can speak because the law is better developed with regard to the Fourth Amendment, and I know Scott is far more of an expert on this than I am. But the Fourth Amendment has been interpreted to include a privacy component. In fact, many of the cases that are dealt with that developed the third-party doctrine was based originally on the property notion of trespass to people's property in their houses. In about the 40s or 50s, the Supreme Court went from a property-based theory to also add the privacy prong. Under these interpretations, if someone has a subjective belief that the information is private, and if it is a belief that society is prepared to accept, then the information is protected. That is how, for example, in those old phone booths that we used to have on the corners, if you went into the phone booth and closed the door of the phone booth, you had constitutional privacy. So it is in the law. It is in the Constitution. In addition, there are various statutes for it. The Electronic Communications Privacy Act, this outdated act, for example, was originally passed by Congress with the intention of providing more statutory protection than the Supreme Court had allowed for things like pen registers and trap and trace devices. The Supreme Court had said that law enforcement did not need any kind of authorization in order to obtain your call-led phone numbers or the numbers of the people who called you. That's a trap and trace or a pen register, respectively. Congress disagreed and said, no, we want to impose an intermediate measure of privacy here. And so they didn't require a warrant, but they did require a different, lower level of showing, but more than what the Supreme Court had granted. And so this is an area where both legislatures can speak, and of course we have the judicial backstop. But let me return to one little thing here that I think is extraordinarily important, and that is this notion of privacy in the judicial test board. You have to have your own personal subjective belief, and it needs to be one that society believes is reasonable. Society is changing now in what it believes privacy is about and what is reasonable. But you need to protect your own subjective expectations of privacy, and then you need to work collectively with the rest of your citizens to talk to Congress and to educate yourselves so that we can evolve as a society so that the courts will then be able to better determine whether this is an expectation which is reasonable.
Aren't you just basically agreeing with my point that there have been interpretations, but there isn't anything that specifically says that the creator of data owns the data, not the party that collects the data?
I'd like to say something for it. You all know Google Fiber is coming to Austin, okay? Well, immediately the day they announced, AT&T said, hey, David, you're always going to do gigabit, right? Okay. But now, you know, they're opening up their kimono and what their pricing will be. Okay? Now, you get gigabit to your home. The pricing I've heard is $99 a month. You know, but just that's what I understand. But if you agree to let them surveil your data, and keep it, it's $20 less a month. So, you see, they realize, just like AT&T, this is AT&T, and it's the same thing we filed with the FCC to adult or HUD when we filed HUD. No one cared about it. A bunch of right-wing nuts is how it's dismissed in progressive circles. But what you've got is the value of it. And I would almost like Scott to talk about your information is privacy, what is property. It's yours. And therefore it's an unconstitutional taking by the government to surveil you under the Fifth Amendment. They are taking your property without due process of law, without your permission. But you gotta act like it's your property rather than, well, you know, that's the third party. You gotta act like you're trying to keep it like it's yours. Saying, hey, I got a fence around, keep my cattle in. You know, I mean, it's like that. You brand them. You take care of your business, you know.
Are there definitive rules? No. But what we're trying to communicate to you is that you are an important part of forming those rules. And the only way that those rules will be established to your satisfaction is if you are active in seeing to it that your political representatives and the courts do it the way you want. Because they do not have an incentive to do anything other than to take your rights and liberties and property away.
Moving on to the gentleman with the microphone.
Considering that I was a former submariner, I know a fair bit about intelligence and spying. I was trained by the government to do it. Considering that during the Cold War, I mean, this is before, I mean, back during the era of DARPANET and the earliest versions of the internet, one of the things that the Russians did was they paid off the people emptying the trash. And they were able to figure out what, you know, top secret projects the government was working on by things just as stupid as the metadata of what phone numbers you're calling and for how long. Considering the fact that most recently the NSA and the CIA, some of their higher-ups, have admitted that metadata has been used in determinations of who they're going to kill and assassinate, could a legal argument be made that metadata is actually far more important than just property? It's a determination of life and everything worthwhile.
Well, I think certainly metadata goes to your free expression rights. Right? The metadata you give off when you speak and stuff like that, and that enables the government to target people, identify who it wants to surveil further. I mean, that's partly a function of your expression. Right? When you speak, how you choose to speak, at what times you speak, those are all connected in some way to your expression. Now, it's not legally protected that way. But when the government targets people on the basis of metadata, it implicates both the Fourth Amendment because, as you said, it directly implicates their privacy interests, but it also implicates the First Amendment because it's tied to the way they're expressing themselves. Now, that will come about more specifically when it comes to metadata related to, say, your Twitter account. So if the government wants to subpoena Twitter and get your IP address information from Twitter because it wants to figure out where you were when you posted that anti-government message to see if you were part of a particular rally or something like that, that definitely implicates your First Amendment expression interest in addition to your privacy interest. As opposed to, say, like, let's say the government wants to know where you were when you were driving on the freeway at 3 o'clock in the morning, that is not directly tied to your expression interest. It's more concretely based on your privacy interests. But I think both the First Amendment and the Fourth Amendment are implicated when the government looks at your metadata, specifically when it looks at your metadata on social media.
Responding to you kind of a little bit deprecated property to the extent that this is more important than property. You write a song, it's your expression. You know, the lyrics, this and that. But the bottom line is it's your property. And we have a pretty elaborate system of constitutional law and developed law that protects your property and people taking it from you without your permission. So we're needing, and as we have the evolving, you know, we see all the cyber stuff we're all involved in, and the fast rate of change that it's hard to even explain some of the changes to people in this room as smart as everybody is and action-wise. We all are still working it out. But when you see the point of my AT&T will give you a $20 a month discount if you give them your property. You sell them your property. So they understand it. You need to understand it. And start acting like, wait a minute, would you pay $99? Or would you take the deal for $20 less? Now Scott says, Ron, tell them to take the $20 less. Let them surveil it, just use the VPN and encrypt it. And take the money and give them the bullcorn. But you gotta start acting like you are somebody. What I do is important. And start acting like a free-born American SOBs and get away with it.
All right, I think we've got one last question here. You want to be the arbiter? All right. Since you have to run it around, I think it's fair that you get to choose as well.
I appreciate it. I just had a real basic question back on before the gentleman spoke. Y'all said it so eloquently that this is your property, that they don't have the right to take your property and look through it. I'm curious to know, here recently the Supreme Court was backing police to seize your cell phone and look through it. Is that real? Do they have the right to do that?
We're still waiting on that decision.
Yeah, I use my phone for work, and I've got company information on it, and I try really hard to get rid of it and keep it clean, so that in the event I do lose my phone.
Well, one way to slow them down at least is to at least require a keypad entry and to encrypt the information that's on it.
So then right now, as I drive home right now, I get pulled over and the guy says, give me your phone, I want to look through it.
Well, I contend they can't do that. There are others on law enforcement who say they can. The Supreme Court should be deciding that within a couple of weeks.
Okay. What the government was relying on there is what's called the search incident to arrest exception to the warrant requirement, which is the idea that when they arrest you, they can pat you down, look for weapons, do that kind of stuff. Now they're saying, like, well, because you could somehow, away from your cell phone, delete everything and erase all the evidence that they might want to take from your cell phone, that they also need to be able to look at your cell phone immediately so that way they can get that evidence before you delete it remotely. But in fact, there are lots of ways the government can prevent people from doing that. There are special boxes they can put in to make sure that the phone can't be accessed remotely and have all the information deleted. But they're relying on these specific, what they call exigent circumstances style exceptions, which is the idea that the evidence will magically disappear if they don't get it right away. And that's what they're using to argue that they need to be able to look at your phone right away without having time to go to a judge and ask for a warrant. But I also want to talk about a different circumstance where the government can do exactly the same thing, which is at the international border. If you're crossing the international border, the law in most circuits, except the Ninth Circuit, is that the government can just take your laptop, take your phone, do whatever it wants, look at it, keep it, hold on to it for as long as it needs to, run a forensic search of the device, look at all the files on it, do whatever it wants, without any reasonable suspicion, no basis for suspecting you for anything, just doesn't like the look of you. They can take your stuff, keep it, analyze it, build a case against you, do whatever it wants without ever going to a judge or even having to justify its decision after the fact. This is what's called the border search exception. What the idea is that when you go through the border, you have no expectation of privacy in anything you bring with you. This was created back at the beginning of the Republic. And it was really the idea that they didn't want people smuggling, drugs or opium or what have you into the country. It was never intended, I think, to cover the vast amounts of personal information that you can just store on your phone or on your laptop, especially in a world where now you basically have to take those things with you in order to function as a professional who's going, traveling across borders. And the government knows how useful this is because we've seen in cases like David House was a programmer in Massachusetts who was involved with the Bradley Manning support network. He was not specifically involved with Bradley Manning, but he was just involved with supporting his legal defense. And the government wanted to know if David House had any connection to Bradley Manning. So what they did was they put an alert in their system. They said, we want to know the next time David House leaves the country. And because they have a system that lets them know whenever anybody's got an international flight going out, they knew that David House was going to go to Mexico, and they knew he was going to come back through Chicago. So what they did was they sent Customs and Border Patrol and Immigration and Customs Enforcement officers to Chicago. And the second he landed, they pulled him off the plane, they took his devices, they analyzed everything on those devices, and ultimately they concluded that they didn't have any basis to suspect him in the first place because he didn't do anything wrong. But in the meantime, they got to look at all his data, and they got to completely evade the normal Fourth Amendment protections that would have prevented them from doing that in the country. This had no connection to the borders. They had no reason to believe that he was going to smuggle anything back to the United States. They just wanted it, and they knew they couldn't get a judge to sign off on it, so they found a special loophole that they used. And the Ninth Circuit has just come out with a decision last year called the United States versus Cotterman, which held that when the government wants to do a forensic examination of your laptop, it needs reasonable suspicion. That means when you go to the airport, they can open up your laptop, they can turn it on, they can look around the desktop. But if you have any password, if your laptop is password protected, if they need to use some sort of software to actually get into the files and open them, or if you have deleted files that you've hidden away somewhere, if they want to look at that stuff, now they need reasonable suspicion. They need heightened suspicion. They need to be able to say, we have a reason to believe you've broken the law related to customs enforcement, and be able to justify that to a judge after the fact.
So when major airports are the Ninth Circuit's ruling?
Let's see, LAX, SFO, I don't know the code for the Portland airport, but the Ninth Circuit covers basically the entire Western United States. It's a major ruling. And the really important takeaway point from this is password protect your laptop. The entire laptop, the entire cell phone. If you password protect specific files, the court said that that can provide the government with reasonable suspicion, because why would you want to password protect this file? That seems awfully weird. In the case at issue, they said, well, he was coming back from Mexico and he password protected some files, so those two things together was enough. That's enough for reasonable suspicion, which seems to me kind of crazy. That's a watering down of the standard. But if you password protect your whole laptop, the court said that that can't lead to suspicion. That's just good practice. So my advice to all of you is, at least when you're traveling through the Ninth Circuit, and probably when you're traveling anywhere, password protect your entire device, and that'll hopefully give the government some delay before it can get on its hands on your private information.
One more thing on that. I know we're talking about the federal standards and what the Supreme Court said you can and can't do. Here in Texas, just to be clear, you asked if you got pulled home or over on the way home. Unless it's a federal agent, the answer is actually no, they couldn't put yourself in. The Texas Court of Criminal Appeals, about 2 months ago or so, the name of the case escapes me, but it's very recent, it got widespread play, ruled that there was a unanimous decision, even the most conservative members of the court agreed with, said that they can't search the phone at the jail instant to arrest. And very, very big deal. The prosecutors in the case, it was a case out of Amarillo, had argued that a cell phone was similar to when someone gets in the jail, gets in their work jumpsuit, they always search the pants pockets. The court said that a cell phone is not a pair of pants. That's a quote from the rule. And so Texas actually does have that protection for state and local law enforcement. So it's not ICE at the border, it's not the FBI. They have their own standards, their own rules, and that's what's being litigated at the Supreme Court. Now, because it is a constitutional issue, if they rule that there is a warrant requirement, that will trickle down to the states. But Texas actually already got there on its own. Court watchers on the Court of Criminal Appeals were just astonished, but they did, and that's very nice.
Hallelujah.
Andrew, do we need to stop now, or do we have time for some more questions?
There's questions.
Great.
If I could ask Brian, since he came all the way down from New York City, well, yesterday on your way down here, the ACLU and some other folks released their poll that 80% of Americans supported updating the Email Privacy Act. With the other 20%, I want to know if you could just comment. If you could just
Diane Feinstein.
analysis.
Andy's beating on her door regularly.
If you could just comment on any conclusions that ACLU has drawn from that, or if you are familiar enough with that to comment.
Well, unfortunately, since I was on the way down here, I did not actually get to see that poll, so this is actually the first time hearing about it. I'm very gratified to hear that 80% of Americans, agree with us on this point. Again, I think it shows us two things. One, that people become increasingly digitally literate, as more and more Americans actually understand, at least on a rudimentary level, what's going on with their email. People care about this stuff. They didn't know what was going on, and once they found out, it turns out this actually is really important to a lot of people. That's very gratifying. And then I think the second point is, again, I think we owe a lot of this sea change in public opinion to Edward Snowden, because he's the person who came forward and actually told us about these secret court opinions, informing us that the government was doing all these things that we thought the government would never do. We said, the government would never do dragnet surveillance. So why would they look at me? I'm just an innocent person. Why would they collect my data? They're just going after the bad guys. And what Edward Snowden's revelation showed us was, no, that's not the case. They're getting everybody's information. They're storing all of it. They're building these brand new data centers out way in the desert in Utah, just so they can just hold on to all this information for as long as they want to. And once people found that out, the obfuscations, put forward by the federal government kind of quickly collapsed. And now I think people realize that this is something that we really need to fix.
Before they were lying when they said they weren't gathering so-called metadata about everybody. They're still lying about whether they're getting your content. They are getting your content. You need to protect it. You need to act to get the laws changed so that they don't do that anymore.
There was a hand in the corner over there that was mixed up. Sorry. Just see on
So right as my hand went up, Brian actually started answering some of the legal portion of my question. So I'm going to focus on the practical portion of, I'm traveling out of the country, I've got my laptop, I've done a full disk encryption, and some TSA agent pulls me aside and says, let me get into this. What can I say at that point that still leaves me with a reasonable chance of getting on the airplane as opposed to spending 24 hours in a small room underneath the spotlight?
Unfortunately, it is fully within the TSA's powers to make your life a living hell. It's unfortunate that they can do that. You can certainly object to, you don't have to give them your password. And legally, they can't throw you in court, or they can't throw you in jail for not giving them your password. So you're fully within your rights to object. There's actually a lot of debate right now. Presumably the government has internal policies regulating the TSA and CBP and ICE about how long they can hold you at the border, or if it's TSA when you're flying domestically, how long they can hold you before your flight. We don't know what those policies are because they won't tell us. The ACLU is trying to FOIA this information. We're trying to get it. We are asking, we're demanding that they publish it. But in fact, the government loves to keep all this stuff under wraps because that provides less accountability, right? Then you can't argue about it with them at the airport or in court.
You can't even prove that they're holding you well. We know the cops can hold you 24 hours without anything, but if they won't publish standards, how do we know if they're keeping us longer than they're supposed to be allowed to?
Right. We don't know the statistics on it. An individual person who's held for an incredibly long period of time would know. But yes, one of the problems is we don't have statistics, accurate statistics about what, how long the government's holding people, who it's choosing to hold, stuff like that. But in general, they can make you miss your flight. Is the unfortunate part of this. If you believe that they're targeting you on an ideological basis or something like that, you might have a First Amendment challenge to that point. And certainly, after a certain point, it's definitely the case, if they hold you for a day at TSA, I think you've got a pretty good false imprisonment case at that point, or, unreasonable seizure. But, if it's for a few hours, I think you'll have a difficult case in court.
I want to follow up on something. You notice how he just mentioned how hard the government works to keep its secrets? Shouldn't you be working just as hard?
Not as bad as they are.
Okay. Well, but this turns to another really important point about our society. Who works for whom? Do they work for you or do you work for them? At some point, the people are going to have to stand up and demand that the government be responsive to their desires. And there's only one way to do that, and it's for you to communicate your desires to the government. They are responsive when enough people do that. We saw that with the SOPA PIPA debate. They were fixing to pass an extraordinarily privacy-invasive set of legislation, which would have allowed people to look at your emails in order to enforce intellectual property rights. They were pretending it didn't do that, but once the secret got out that they were, in fact, about to invade your privacy in this fashion, there was an uproar. It was engendered by the Fight for the Future folks, bless their souls. Okay? But all of a sudden, Congress was rocked. It was a distributed denial of service attack. They couldn't get any more emails, they couldn't get any more faxes, and their phones went out of service. And you know what happened? They were responsive. This is the sort of thing that is required.
Now that thing was all teed up with our congressman here, Lamar Smith, but with, he's a Republican. But the Democrat running in Lady in Vermont, it was like he was head of the Judiciary Committee, chairman in the Senate, and you had both those guys with more seniority than God. And you know what? It was going through, and everybody in the Congress knew it. It was a fait accompli, done deal, passed the fees to the next course. And it just took all those emails. And it's going to take that. That's the vote. You know, it's the protest. It's the block the road. It's you're going to have to be Americans.
So, by the way, don't encrypt that email.
Encrypt it with their key.
Any final questions here? One over here in the back.
So I've heard a lot of people talk about the government and the situation we're in and how we get out of it. But one thing that I haven't heard anyone mention, I was in Representative Hughes's committee hearing this last year. For those who don't know, that was the one that we were talking about the cell phone data. It lasted until like 4 in the morning. I think it was the longest running committee hearing ever, or at least that I've ever experienced. And the one thing that I didn't hear was a lot of these people like to protect their own data, but they were willing to defend the idea of defeating this bill to give up other people's data. They called them criminals, the bad guys, the suspects. They painted a lot of really good fear, and that's ultimately what kind of defeated that bill. We all have to remember, most of us supported Patriot Act, most of us supported all these intrusions right after 9/11. And they called those of us who did support it, they called this, nuts, okay? One of the things that I haven't heard anyone talk about yet is, what are we going to do the next time we have a 9/11? Are we going to say, wow, that happened, let's heal, let's get over it, let's find the guy who did it. So be it what happens to him, but don't give up our own freedoms? No, I guarantee you the next time, everyone in this room, everyone in this city, everyone in this country, the vast majority will be saying, let's pass another law, let's give up some more freedoms. And the rest of those of us in tech are going to be the ones who get those warrants. And we're going to be the ones who have to deal with it.
Let's hope that's not.
Well, and that's what we need to focus on, is what we do the next time, not just how we get out of the situation we're in.
There were those of us at the time of the USA Patriot Act who were warning of the extent to which folks' privacy was being surrendered in the name of protection. There were some.
I think now is when we have to remind them that we're in this position because we all consented, as a democracy, we consented to this mess. Now we have to clean up this mess. It's our mess. We have to own that mess.
Fool me once, shame on you. Fool me twice, shame on me.
Amen.
I just want to say something. I'm kind of with him on this. I have about 200 something users, and they all say the same thing. I've got nothing to hide. I don't care. I got nothing to hide. And I can't stand, as a network security, I cannot stand to hear that, because you don't know what you have to hide if you don't know what it is. And ultimately, in the end, you go, crap, I did have something to hide back then. And it's a mess. And when everybody, especially our younger generation, when they're all thinking the same thing, that just gives away all of our freedoms. And again, we're going to have, all it takes is another 9/11, and everyone's to say, look, this is why we need this, and we need to be invaded so that we don't have those things. And that is completely wrong thinking. I don't know how or what it's going to take to change the habits, the thinking habits of our society who believe that they have nothing to hide. And I don't really know where I'm going with this, but just that something does need to be done.
Everybody has something to hide in the surveillance state.
So I'd like to put this in the
hands off. Let's get it on.
Let me get your thoughts on this in closing. So why should people care about their privacy, and what's the best way to defeat the canard that you don't need to worry about your privacy unless you have something to hide?
Well, I think first, we're in a different historical moment, and if something were to happen again like 9/11, I think the response might be something different. Some of the response might be, hey, some of the things we did last time were stupid and counterproductive, and maybe just starting a bunch of random wars, in places we don't need to be in, and diminishing civil liberties. That didn't really work that well last term, or wouldn't have been. And so I'm not so certain that it would just immediately trigger that. And I also think that the 4v1's attitude. People are always fighting the last war, and the last war in this case are these after Iraq, Afghanistan, Patriot Act, all that. And there's been sort of a collective set of lessons learned among the public, among the opinion leaders, and I don't think could even go to mitigate, like give an opportunity to mitigate some of the stuff in the Patriot Act that just seems true, because it hadn't helped, and nobody really thinks that any of that is what's like keeping us from being attacked.
What did it do in Boston? In fact, that was a real event. Didn't prevent anything in Boston.
That's right, it didn't prevent anything. And in fact, the surveillance that really mattered, ironically, was like stuff people caught on their cell phones. It was that crowdsourced sort of stuff. I'm fairly optimistic. I feel like, having worked on some of this with folks at the Texas legislature, you're asking people who are going to consider, in Texas, there's 7,000 bills filed every year that pass 1,000. That's in 140 days, every 2-year window. It really is less than that, because you have 30 days at the beginning, 30 at the end, where you kind of aren't really in the thick of it. And so they don't have a lot of time to think about positions. Their gut instinct, that sort of first, how they feel about it when they first hear it is, matters for a lot, because they just don't have much, they don't have time to learn much. I don't blame them for not having been more aggressive. This stuff is obscure, it's difficult, it's never been done well, they don't have a lot to work with. I think I'm a little less of the people united will never be defeated, sort of mentality. To me, the people united get their butts kicked all the time. Like, all the time. Just everywhere you look.
But if they're not united, they get their butts kicked every time.
Well, my point is, though, I think that actually the Texas legislature, I cannot speak to Congress, they're actually ready to do the right thing. They need knowledgeable opinion leaders to step up and show them what the right thing is and get the bill done right without making things worse, because it's always possible for the to make things worse. And that's the state level too. That's where we're at. What the challenge is. Right.
So I think I'll make 3 quick points. The first is that you don't know whether you have nothing to hide or not. Because you don't know what's going to be of interest to the government going forward. I mean, it wasn't that long ago in this country that J. Edgar Hoover ran the FBI, and if you were against the war in Vietnam, you had something to hide. And just recently, Eric Holder, in a speech, said that, yes, it's important to focus on Al-Qaeda and these other terrorist, Islamist terrorist groups, but we also need to focus on groups that have anti-government bias. So if you have an anti-government bias, maybe you've got something to hide. You don't know going forward what's going to be of interest to the government. It might be something completely innocent, but then the government thinks like, whoa, this is a red flag, and then your whole life gets thrown into the criminal justice system, and hopefully you come out of it without a conviction. But your life will definitely be changed for having been thrown into that process, for having been investigated by the FBI. You might lose your job, you might lose your friends, I mean, who knows? So innocent things you do can be misinterpreted by this vast federal bureaucracy, and then you do have something to hide. My second point is that there's lots of stuff people do that's not illegal, that the government has no justifiable interest in getting, that they might not want other people to know. Whether you see a therapist, whether you have a mistress, if you're a heavy drinker, where you go to church, stuff like that. Again, not something illegal. You haven't committed any crimes. You shouldn't be thrown in jail for it. But it's stuff that's private. You don't want other people to know it. It's yours. And I think that ties into my last point, which is that Having privacy is about having a little bit of space, in this crazy modern world, to just be yourself without having to worry about whether people think of you or what they're going to see in it or how they're going to interpret it. And if you're constantly knowing that someone else is watching, even if you know it's just logged into some big NSA database and probably no analyst is ever going to go actually searching for you. There's a lot of studies, psychological studies that show that, on tests, if they just draw little eyes on top of the test, people take the test differently. Because just the feeling of someone watching you, knowing that your actions are being recorded, will change how you act. So maybe you'll be just a little less vocal because you don't want someone to misinterpret your anti-Obama message. Maybe you'll be a little less sincere with your loved ones because you don't want, just in case somebody, some NSA analyst is looking at it, it might be embarrassing to talk about what you did last night. And then you'll just be a little less human. That's what we need to live in this world. It's just like a little bit of space knowing that it's just yours and the people you choose to share it with.
Final thoughts?
Yes, I'd like to say this because I'm going to say for all of us to have kind of a civil society, we do need to have police power. Okay? And we need to have the police do things that do the dirty work. With the sewer that runs through all our communities, But, so they do have legitimate reasons, based on probable cause, to get some of the data that we as service providers have. But you gotta make them dot their I's, cross their T's, and not just be sloppy. Because they'll ask for the kitchen sink. You gotta learn how to say no. It's okay to say no when they're got 2 FBI agents at your office. You say no, we're just not going to do it that way. And, they're not going to arrest you on the spot. Now, you might feel a threat to your freedom, but you can say no. But you're going to narrow it down, and that's part of what you got to do. And that didn't come in the Linux, manual. Okay, but it's coming in our manual for just being a resident of this country. But nevertheless, some of us are going to have to operate a server or something online or have somebody else's stuff. So you can say no, but they do have, once they present, proper stuff, and, go out the back door and ask a criminal defense lawyer or someone that deals in online stuff. But still, I want to say, stuff is going to get given up to law enforcement. It's just not with broad surveillance, no cause, no articulable reason to a judge. That's why we put a search warrant. They got to go talk to a judge. And this FISA judge, this kangaroo court, we all studied in law school about the Star Chamber in England, where it was secret indictments. A lot of the U.S. Constitution is a reaction to it. And here we're getting it. And this to me is not a court. This is a secret court. And the other side didn't get to show up. And until that appellate court decision here just a few months ago, you couldn't even say that you were I can tell you I'm serving a search warrant. I can't tell you I'm serving one of those warrants. And, I think, personally, the mass movement, I just think each of us acting as individuals, right, providing that leadership that, with Brian Hughes and that geolocation legislation, we were all involved with that talk with law enforcement at that time. We got them to cooperate with the prosecutors on the email, not resist it. Back before they loaded, and they're still loaded, they want to surveil on be able to go by the cell towers and grab stuff. They want to just get it all the time. So they see that, we'd give up your civil email. Okay? We want your cell phone, your mobile, because that's tracking us even when it's off and all that stuff. So, but I encourage you to speak up. It's you individually who's going to do this. It's not the government. The government is the problem. The Constitution was established, as Jefferson said, to tie the government down with the chains of the Constitution. I would say it's not tied down at all right now. How do you back down?
Those of y'all who are service providers, you do get paper. You know, it is intimidating. Ron says, yes, you can say no on occasion, but you don't have to get to no immediately. One of the things that you can do as a service provider is take advantage of the thing that you know, that quite often the law enforcement agent who is coming doesn't know, and that is the technology. I strongly suspect that most of the warrants or other subpoenas that y'all receive, and trust me, I've reviewed a few, have some technical requirements in them. They require you to take specific steps. Well, while you're trying to find the phone number for the lawyer that you're going to call and sadly have to pay for, why don't you sit there and talk to that guy and say, wait a minute, I don't understand this. You know, after all, I'm running Linux here, and this is Microsoft. You know, I don't have that kind of server. What is it you want? Use your own knowledge to pick apart what they have given you until you can buy some time to find a lawyer. Put them on your own turf. And I do suspect that if you actually look at what they show you on many occasions, you will be able to fairly quickly see that the thing they're asking you to do, you may not be able to do. And they got to go back and rewrite it. Or you may not be able to do it the way that they want you to do it. Or it requires certain steps. And another thing, let me give you another lawyer tip. If you are served with paper of this, most of the statutes involved allow you to charge the government for your reasonable time and cost of compliance. Why don't you start negotiating with them about how much you're going to get paid for it before you comply? That'll buy you a day or two. So there are any number of ways. Of course, I'm not suggesting you should do this in bad faith. There are some steps to this, however, that are legitimate and are built into the statutes. They will try to intimidate you to skip over everything that you have rights to do and not do, and to do everything that they want you to do on their timeline and in the way that they want. That's not even the way it works under this regime. So read the paper, make sure you understand it, ask questions, and one of them is, how much are you going to pay me, and when am I going to get paid?
Andrew, how are we going to time? Another question?
Yeah, one more, rather.
One final question for the gentleman.
I have one question. Who is the constituency of the NSA? Who is writing big campaign contributions to keep the NSA with its power? What section of the voters is going to vote for candidates that are in favor of the surveillance state? Where is the political power that keeps this thing going? I don't understand that question. I don't think there's any power there at all except social inertia.
I agree. It's us asleep, not voting, not caring, thinking the other guy's taking care of it, or the government's going to. That's the constituency, is apathy. Okay? It's just the other guy. I'm a geek. I don't do this. You know, someone else does that. Well, that's how it happens. So, yeah, it's the acquiescence in the large Defense Department bills buried in there. You know, it's our acquiescence to this. I would say also to you that's not the social welfare state is tremendously demeaning and intrusive. We thought, well, the government, I'm here to help you. But what a person that's got to request benefits from the government, besides being a VA vet and wait in line a year and die, the social welfare state just has tremendous amount of stuff that you've got to trade them for access to government services, and then they continually surveil you to make sure you're, staying with it or not. But I mean, you're given that we have all that bureaucracy and administrative stuff collecting and preserving and wants to protect their ability to do so. But we've acquiesced. I'm going to say we've been doing this stuff for about 10 years. And I mean, even earlier today talking to people, it's a hard question. just find a hard time believing it.
And Ron, I'm gonna
Sure,
mention
come in.
again, Brian, real quick, and then we're gonna kick that off.
Just to add, one group that I do think provides a strong constituency is the defense contractors. Booz Allen, Northrop Grumman, I believe Boeing's involved as well. I mean, these are major companies, Lockheed Martin, thank you. These are major companies.
If they didn't have the power to pass warrants or to have automatic surveillance, then doing what they would doing now would be more expensive, not less expensive. That would need more money for defense contractors, not less.
They would be able to do less of it than they are now if they had to get warrants. Right now, they can do it on a mass dragnet scale because they don't need warrants. If they had to get warrants, they have to pay the DOJ lawyers who are already on government retainer. But they wouldn't need to necessarily pay the defense contractors more. They'd be paying them less because there'd be a lot less data for those contractors to analyze, to collect, store, and analyze. So it's the fact that the widespread nature of the surveillance is of heavy interest for the contractors because they're the ones developing the algorithms, they're the ones running the scans, they're the ones doing all the intelligence work on this. A lot of that NSA work is contracted out to places like Booz Allen.
Snowden worked for a military contractor.
Yeah.
All right, well, I want to thank the panelists, Ron, Scott.
So we're going to take probably about a 10-15 minute break, and we have a presentation on Going Frog, who Going Frog is.